No, let's say good morning to Attorney Ben Salango. He is the Kanawha County Commission President, and he joins us via telephone as he did last Thursday. Ben, welcome back.
Good morning. Thanks for having me back.
You're welcome, sir. Have you gone through any of the fun paint that Mr. Gilstrap was talking about for the house?
I have painted the house a time or two, and just like you, we've tried for months to find a different color and could never agree to one. So I just always paint it the same color.
That's how it
Although
works.
I'm curious about John's jacket. Maybe that would be a nice color for the house. That very pale yellow that looks like white.
It almost looks white from here, right? Like a cream color almost. Yeah.
Yeah, I'll accept cream. Yeah, that's yeah.
It's not easy to get you to accept something that's different from your opinion at times.
Well, yeah, unless of course you persuade me to change my opinion.
Yes, which I may have done there a little bit.
You've done that before, Rob.
Yeah, yes. Ben, we talked last week about a sports complex, which we had not intended that conversation to go as far as it went, but it had some legs to it. So you had a lot of interesting information, but we wanted to follow up you this week on your feelings that the penalties for murder in the state should be much more severe than they are at this time. And you come at this from personal experience. If you could recap that personal experience for us as you did late in the interview last week.
Yeah, so people, when I published the op-ed, and we had a lot of outlets cover it, and I'm very appreciative. Getting the information out there is important, but the people were messaging me, why are you doing this? What's going on? Because I didn't lay out the personal experience. Some people in Kanawha County are aware of the situation because it was a high-profile case. But when my wife was 16 years old, her older brother was murdered. He was a college student. He was in the Army Reserves. He had a very bright future. He was in his mid-20s, and he was brutally and savagely killed. One of his coworkers pulled out a 9-inch lock blade knife and stabbed him in the neck. There were defensive wounds. It was awful. And after the suspect was arrested, and they told him that the young man had died, his response was, "Oh, well, do you think it's going to snow today?" And so it was callous. It was intentional. It was there was absolutely no remorse whatsoever, which then kind of threw the family into this system. They had to sit through 2 jury trials. The first jury convicted him of first-degree murder. It was overturned on appeal because of some things that the prosecutor said and also a legal issue about whether or not you can form premeditation by pulling a knife out of your pocket and opening the blade, and is that sufficient time to form premeditation? Of course, the Supreme Court said that it was and sent it back again for a second trial. The second trial resulted in a first-degree murder conviction as well, but the jury recommended mercy. Now, what that means is the jury found that he intentionally, willfully, and premeditatedly killed my brother-in-law, but they said, we're going to allow you to come up for parole at some point. Well, back then, you actually came up for parole on first-degree murder after only 10 years. And so what we've been doing for the last 20-plus years is every 1 to 3 years, we've had to show up at a parole hearing. We show up, we have to argue to try to keep the man who intentionally killed Todd Farley in prison. And it's grueling. It tears it's like removing the scab every time we go back in front of the parole hearing. The family gets upset. It starts happening like a month or 2 months before the parole hearing because you don't know if he's going to get out. And one of the terrible situations here is that in addition to killing her brother, she had 2 brothers at that time. Her other brother witnessed it. And so her younger brother witnessed the murder. The older brother was murdered. And so this has had a devastating impact on the family. And then every time he comes up for parole, we don't know if he's going to be back out in the community with us or not. So my position has been, they actually changed the law from eligibility for parole in 10 years and moved it to 15 years. That's not enough time. I mean, let's be honest. If you go to the bank and you take out a home mortgage, it's probably going to be a 30-year mortgage. You should not be able to kill somebody intentionally, premeditatedly, and be eligible for parole in half the time that it takes to pay off a mortgage. It's not enough time. It puts the families through absolute grief and terror and just this emotional roller coaster every other time. And the parole board gets to pick whether or not they bring the person back, the perpetrator back, after 1 year or 3 years. It's incredibly rare. In fact, I haven't seen it, where somebody who is convicted of first-degree murder is granted parole after 15 years. And so my point is, why have it? Why put the family through that after, at the 15-year mark, the 18-year mark, the 21-year mark? Why have them do that time and time and time again when that person should not be eligible for parole, in my opinion, for 35 years? West Virginia is the most lenient state in the nation when it comes to parole eligibility after first-degree murder. We're tied with Ohio. So 48 other states have more stringent penalties for first-degree murder than West Virginia. And it's time that we brought our code up to date. It's time that the legislature looks at this and, quite frankly, looks at it from the perspective of the victims rather than the criminal. The whole system is set up to be, has the criminal rehabilitated? Has the criminal gone to the classes in jail and in prison? And have they gotten their GED? And have they participated in a home plan? And all these other things, and completely lost through all of this is what the victims have to go through. And so the point of my op-ed, the point of this mission, quite frankly, is to get that change. It will not affect my family. It will not affect my wife because that he's going to be under the old system. But what we're trying to do is keep future victims from going through exactly what we've been through.
So, Ben, help me out with the parole hearing. I have not attended one. Is the onus on the prisoner to prove rehabilitation, or is the onus on the victims' families to prove reasons why the murderer shouldn't get out of prison?
Ideally, both would have a speaking role at the hearing. And so since COVID, the parole board no longer has in-person parole hearings. I'm not faulting them for that. I think it's much more efficient, quite frankly, just as effective to have them virtually. But the families can't get links to the virtual hearing. So the family has to sit around a telephone and hope that the call doesn't drop, hope that you don't lose signal, hope that you can understand what's going on the other side, and quite frankly, hope that you get an opportunity to participate. While the criminal, the murderer, has a link, gets to participate remotely, and the families don't get to participate at all. We have by the way, I've been to 8 parole hearings now. The families, we request a link, we request to go in person, and every time we are told we will get a link, and we never get one. Now, we're probably, as far as the system is concerned, I'm a lawyer. I've been practicing law for 27 years. My wife's a lawyer, and now she's a judge. I think we're probably sophisticated when it comes to the system. I can only imagine what the people who aren't sophisticated and don't understand the system are going through, how confused and how left out and how disappointed, quite frankly, they have been over the years trying to keep the person who murdered their loved one in prison without really any meaningful ability to participate. In fact, I sent a FOIA request to the parole board because one of the things they look at is the murderer's criminal file. And so they go through in detail. Well, congratulations, you got your GED. That's a good thing. Congratulations, you did this. You haven't had so many write-ups. So I said, hey, you know what? As a family member, as a victim, let's get the parole file. And so I sent a FOIA request, and I'm sitting there holding it in my hand. It's a one-page response. Sorry, you're not entitled to the file. Really? I mean, you can't get information. You can't see what the parole board is purportedly seeing, and you can't really get meaningful participation. And that system has to change. So really what we're looking at is a two-pronged approach. Number one, West Virginia needs to get its law up to date with respect to keeping people in prison for first-degree murder. This is the intentional, premeditated killing of someone. You should not be eligible for parole in 15 years. That's an absolute slap in the victims' faces. Number two, there needs to be a better system. You can do anything virtually now. You can get a bank loan. You can get anything virtually. With a DocuSign, you can watch public proceedings on YouTube. You can do all this. Why in the world is the parole board so far behind that it can't even figure out how to send a link so the victims can participate in a virtual hearing. That is, you can create a link in about 10 seconds and shoot it out by email or text. And for some reason, the parole board just can't figure that out, can't figure out how to do it. So we're trying to change that system as well so that other victims' families can meaningfully participate, and it doesn't look like the entire system is fixed in favor of the murderer instead of the murder victim.
And you'd like to change it to how many years at a minimum before parole can be considered?
I think to bring us in line with other states, it needs to be 35. Look at Puerto Rico. If you, and I know it's not a state, it's a territory, but if you kill somebody, first-degree murder in Puerto Rico, you're not eligible for parole for 99 years. There are other states, which is, essentially it is a life sentence. There are other states that have 50 years. There are other states that say, regardless of whether mercy or no mercy, it's going to be a life sentence. You don't get parole. I'm not arguing no parole when a jury recommends mercy. I respect the jury system. I respect what the jurors have to go through. It is not an easy job. People think it's easy if they follow 30-second sound bites on the news. It's not an easy job. As a trial lawyer, I've tried over 50 cases. So I think that what we need to do is stiffen these penalties, bring us in line with other states, even the liberal-leaning states, New York, California. You go up into the northern United States like Vermont, New Hampshire, some of those that Maine, we would call liberal-leaning states. Even those are 25-plus years before they're eligible for parole. So why is West Virginia so far behind? Delegate J.B. Akers was on Talkline the other day, and this bill has come up a few times, and it's been defeated. And one of the reasons why, and he is an incredibly intelligent attorney, very well-reasoned and understands this issue better than most. One of the reasons why is we've had prosecutors, I guess, who have opposed it, saying, well, that may cause difficulty us getting plea deals. If they know that they're going to be in prison a minimum of 35 years, they might not plea. And J.D. pointed that out and as to why the bill failed last year. First of all, it was a different bill. It was like more of a complete overhaul of the system. But so my response to that point is, and first of all, it's a valid point, but if you're going to charge somebody with first-degree murder, then presumably you've got the evidence. And first-degree murder, if they're not going to take a plea deal, and if you're not going to respect the victim's family's wishes, then you should try the case. It is, and sometimes victims don't want the case tried. I get that, but quite frankly, you owe it to society as well to keep this murderer off the streets. There's not a lot of evidence, not a lot of research about whether people who are convicted of murder and they do 25 to 30 years and they get out, will they reoffend? There's not a lot of research. There's not a lot of study on that. But I'll tell you what, again, you're looking at things from the criminal's approach instead of the victim's families. I can tell you for certainty there is a tremendous amount of grief and heartache and anxiety when that person comes up for parole. And so if they are looking for concern, the prosecutors are concerned that it may screw up plea deals, I get that, but you also have to look at making sure that this person stays in prison. And if you don't have the evidence to convict somebody for first-degree murder, don't charge them with first-degree murder.
Mr. Doyle.
Yeah, hi, Ben. John Doyle. First of all, I agree with you that the reason that bill failed was it was a complete overhaul of the system, and a whole lot of people said, well, wait a minute, what is in this thing? And that I think it just died of its own weight. Now, I imagine you saw the op-ed 2 days ago in the Gazette-Mail by Steve Logan.
I did not.
Oh, I think you need to. It was a rebuttal to yours.
Oh, well, thanks for telling me. Nobody told me.
Yeah, it was in the Gazette-Mail on Tuesday, I think, maybe Monday. And he was a correctional educator for a number of years. Mm-hmm. And I will say to you that much of what he said, I understand because after I graduated from college, for about a year, I was a classification officer in the Maryland prison system before I went into the Army. And one of the things that he points out, which I agree with, is that of all the types of crimes that people end up in prison for, some of the folks who are most easily rehabilitated are those who are convicted of first-degree murder. They're the ones that once they get back out on the street end up being solid citizens, much more so than, say, bank robbers or manslaughter or any of the other crimes that you name. And I think it is because, I don't know this for a fact, I'm guessing it's because in many cases, I suspect this is not the case with your family, but in many cases, it is someone who got so mad at a particular other person that they planned to have that person killed, and there they go. It's not the same as somebody who is a professional hit person for the mob, that kind of first-degree murder, no. And usually, when the case goes to court, you can tell the difference. So anyway, I will throw those things out for you, and I'm sorry you weren't able to see that. I just figured you probably had seen it because it was a direct rebuttal of yours, and I guess I'd like to have you back on here again after you've read that.
I'm actually reading it. I'm reading it right now. I'm listening to you, but I'm also reading it. But here's the point to that, and okay. I understand what Mr. Logan is saying because I've seen these points before. Again, it's somebody looking at it from the prisoner, from the murderer's standpoint. Oh, well, they can be rehabilitated. Well, that's great. You know what can't be rehabilitated is somebody who's been murdered. That person is not going to have a chance to go on and go on to higher education, and they're not going to have a chance. So we've fallen into this mindset where we are ignoring and not honoring the victims, and we're focusing on the murderers, and which is what his op-ed certainly does. And I respect that. I respect his opinion, and I respect his time that he served at working at Mount Olive Correctional Complex. But that doesn't change the fact that he's looking at it from the perspective of the killer and not the person who was killed.
I would dispute.
Ben, I'm sorry, go ahead.
I would dispute that a little bit, maybe him. But in my case, I'm looking at it from the standpoint of society. And that's what the parole board is supposed to do. And you are right. In some cases, they should not be allowed to even come up for parole. And that should be a category of sentencing. In some cases, yes, someone should not be eligible for parole. But if they are, and incidentally, Steve Logan, I think, is right about this. This was my experience. I went into many parole hearings during the time I was a classification officer. That's what they called it. And the parole board then, this is 1968 and 69 in Maryland, was you really had to have a super high charge case on behalf of the prisoner in order to get the parole board to even consider parole.
Hey, let me get to John Gilstrap before we run out of time. John?
Yeah, but excuse me, the terrible thing your family went through. I can't imagine. Isn't it a quirk of the law, though, that murder is actually not a crime against the individual? Murder is a crime against the state.
Yeah, well, the state charges it and the state prosecutes it, but the victim obviously is the individual.
But does the victim have? And this is because I'm just trying to understand. Does the victim actually have standing? Because they don't really have a voice. They don't have an attorney. The attorney is for the state.
Correct. Yeah, the victim doesn't have necessarily standing. I would love to be able to, in a perfect world, you could hire your own lawyer and prosecute it yourself, but that's not the way that it works. So the state has standing. The victim and the victim's families typically are witnesses. In a murder case, it would be the family and other people, but it's not it's certainly not the victim with the standing to prosecute the claim.
And is that the basis by which they justify the exclusion of the family through some of these considerations?
Yeah, I don't think they're necessarily excluding the family from parole. And, it used to be that many times the families wouldn't even get notice of the hearing. And so the murderer would be there unopposed and would get out. And so now there is a statute that requires that victims' families get notification, and you typically will get a letter. The problem is you don't get to meaningfully participate. And one of the I'm looking at this op-ed still. One of the issues that he says is a mandatory minimum of 15 years to life reflects the gravity of murder. And I can tell you that is absolutely untrue. In fact, 48 other states have said that's untrue. 48 other states actually recognize that 15 years is insignificant when you take somebody's life. What he deprived, you just look at my brother-in-law as an example. He was in his mid-20s. He had another 50 or 60 years to live. And his family, this caused his brother who witnessed the murder to now have severe mental issues. It deprived him of a gainful, meaningful life. And so,
Ben, on that note, I've run out of time. I apologize.
Yeah.
I've got to end the segment here. We're on a strict time limit here.
I understand.
Sorry once again for your family's experience. I appreciate your time this morning, and I'd love to follow up on you with this as the legislative session gets underway in the winter.
Absolutely. You call me anytime to talk about this or sports complexes, and I will talk until you tell me to shut up.
Thank you, buddy.
Thanks so much.